Okay.
Great.
Yep.
Good morning, everybody. Let's go ahead and get started. I'd like to call to order this meeting of the Texas State Board of Examiners and Professional Counselors. Today is Friday, January 20th at 9:00 a.m. We are meeting today virtually through teleconference via Zoom. I'm going to go ahead and do our roll call. Call out your name. Please introduce yourself. Dr. Christopher Taylor.
Dr. Taylor, Vice Chair of the LPC Board.
Ms. Janie Stubblefield.
Janie Stubblefield, LPC Supervisor, Professional Member.
Dr. Leah Amuna.
Dr. Leah Amuna, professional member, Texas A&M University, Central Texas.
Dr. Loretta Bradley.
Dr. Loretta Bradley, professional member, LPCS supervisor, faculty member, Texas Tech University, Lubbock.
Ms. Brenda Campanone.
Good morning, Brenda Compagnone, professional member.
Pastor Roy Smith. Frozen up. Pastor Roy, it looks like you're locked up. There you
it
go.
goes.
Try again.
There we go. Okay. Yes, Pastor Roy Smith, public member.
Thank you. Ms. Vanessa
Yes,
Hall.
sir.
Good morning, Vanessa Hall, public member.
And I am Stephen Hallbauer, public member from Richardson, Texas. We will note the absence of Garrett Nairn. Christina, please introduce staff.
Good morning. My name is Christina DeLuna. I'm the board administrator for the LPC board. We have Patrick Hyde, who is our general counsel, Tim Spear, who's our operations manager. Victoria Benitez is one of the attorneys for the LPC board. And we may have Mr. Long log back in here in a little bit, who is the other attorney for the LPC board.
Thank you very much. Item 3, board review regarding applications. Christina, please verify that we have none for today.
We have none today.
Thank you. Item 4, discussion and possible action regarding orders executed by the board chair. Christina, please verify that we have none today.
We have none today.
Thank you very much. Item number 5, orders for first quarter of the fiscal year. I'll hand it to Christina.
So we did have 10 agreed orders that were executed by the BHEC executive director. Those are in your packet and were included in the board packet. I'm sorry, in the public material as well. So those have already been executed and no action is needed by the board.
Any questions on the orders? Hearing none, we'll move on. Item 6, reports review. Christina.
So in your board packets, you will have the performance measure report, the enforcement status report, as well as the complaint dismissal report. So staff continue to, on both ends, on licensing end, as well as the enforcement and investigations, and they are just moving through these investigations and applications and getting people licensed and taking care of the people who are violating board rules. So it's great to see that we continue to move forward with all of that. Also, that's in the board packet material is the licensing data that you have there for the different months and years. So you can see the increase that we continue to get in all the programs and especially in LPC.
Board, any questions regarding first quarter performance measures?
It just appears to me, Mr. Chair, that these numbers are trending down. Is that accurate?
For the complaints?
Yeah,
Yeah, absolutely.
it's good.
Yep.
Thank you, Christina. Y'all keep up the good work down here. Moving on, item 7 is SOA matters. Again, I'll verify that we have none for consideration this morning.
Correct.
Thank you. Moving on.
Mr. Chair, if I can real quick on the performance report.
Sure.
We have 3 that are pending from 2017 and 2 from 2019. Can we get those? Do we know what the holdup is on those, Patrick? Can we get those sort of escalated?
So this report is for each fiscal quarter. So technically, as of today, that 3 in 2017 is a 1. And I think the 2 in 2019 are still a 2. So we're down to 3 of those pre-2020 cases. The 1 in 17 is filed at SOA. So I mean, it's moving forward. And then 1 of the 2 in 19 is filed at SOA. The other one that's not filed at SOA is actively being negotiated, and it's hopeful to resolve without going to SOA. But you know, if we can't reach a resolution, the next step is push it down to SOA so we can get those to zeros.
Yeah, that would be good. I would like to, I think it's probably in our best interest to get those resolved.
Everybody agrees with, we would like to get rid of those numbers, yeah. I think too, because again, the numbers are for the previous quarter. And so we're currently in the next quarter. I think that total number too is a smaller number as well. As we sit right now, the problem is they keep coming in. So I don't know what the final number will be for next quarter, but I believe, speaking with Alfonso Fernandez, the enforcement manager, we were in the 300s, I think, so.
Thank you, Patrick. Any additional questions? Okay, hearing none, we will go ahead and move on to rulemaking, item number 8. Letter A, this is our final discussion regarding proposed CE rule changes, the new 681.140. The proposed changes were published in the Texas Register on December 16th of last year. We received a few written comments. I would make note of the written comments that we received from TCA, from Texas Medical Association, as well as Chair Christopherson for their comments provided through written comment. Appreciate your thoughts on that. Not a whole bunch more. I did go through the ones that we did receive. Few comments along the lines of, well, I think this is a little too onerous, to, hey, this all looks good, way to go, keep it up. There was not a, there was certainly not the volume on written comment that I personally expected. And there was nothing that really stood out in the way of items that we hadn't considered at this point. I feel as though we did do a good job kind of building a consensus new rule that incorporated a lot of people's opinions. We did hear from the public originally when this went back and forth between our board and DHEC. We made some changes then. The rule that we have now, I think, is a pretty good one. However, this is our final opportunity to discuss it, to respond to any of the written public comments that we've received, for any kind of final thoughts before we vote on making this proposed change official. So at this point, I will ask the board, any impressions from the written comments that you want to address, or any thoughts from the over New Year's that you want to bring forward now. This is the last chance to really get your thoughts out, and before we take a vote on this, let's have a final discussion on it.
Mr. Chair, could we have public comment first? Would that be agreeable?
The public comment is going to be reserved for the new proposed rules, the informed consent. We've had public comment on this. There was Christina sent out the the analysis provided by the governor's office regarding their impressions on the rule. They did give us the thumbs up on everything. If you had a chance to go through that letter, I mean, it was kind of snuck in here right before our meeting, but if you had a chance to go through that letter, they don't have any issue with it. They say it's a good balance between our authority to regulate the profession as well as not creating any sort of what they would say would be an unnecessary burden. The governor's office did approve of the rule change. They did, the proposed rule change. They like the fact that it is in congruence with our other mental health boards. And like I said, they kept going back to that they view it as a good balance. And that's how I view it. This was a very tennis match type of back and forth between our board and BHEC. And I feel as though the platypus, if you will, that came out of this is pretty good. I think it's a good rule change. Patrick.
Mr. Chair, too, I would just to add regarding the letter from the governor's office, what they that was submitted. All of these CE rules for each of the boards was submitted to this regulatory compliance division in the governor's office, specifically because people had raised some anti-competitive concerns about the rules, and so the review is specifically done because the governor's office reviews those and makes a determination, on. Is this anti-competitive? Is it not? Is it something that the agency can adopt, or is it something they shouldn't? And so it's good to note that they approved this one as well as all the other CE rules. I would strongly caution against making any changes to the proposed rule as we have published it, because this letter is effective for what we have published. And so if we start making tweaks at this stage, this letter, the value of it becomes less. And so if we would like to make changes, I would recommend that we would adopt this and then take whatever recommended changes to the rules committee to then re-propose it at a later date. Therefore, this create, using the full effect of this letter to protect the board against any sort of like anti-competitive claims that could be done later. But in short, the letter says it's all within the agency's power to do, and they approved it. They didn't have any problems with the rule as drafted. And I will say, to your point, originally we proposed a rule and it got kicked back, and through that process we reproposed it with some changes, and all of the other boards took your homework, LPC board's homework, and copied it for their rules. And so they're now either they've adopted or are in the process of adopting and changing their rules, basically to, while it's not a perfect mirror match, it's pretty close. It's pretty close to what this rule is. So they're all very, very similar.
Thank you, Patrick. Yeah, to Patrick's point, this is the culmination of a year's worth of work on this. I mean, this was brought up February of last year. This is the culmination, and I think it's the best possible new rule that we came up with. A lot of time went into it, and to Patrick's point, once this kind of began in the system, it was the LPCs as well as our Texas therapists that really drove the wagon on this and kind of led the change that is now affecting our other mental health boards. So a good job on this. Do we have any questions? And if there aren't any questions, I will need a motion.
Do you need a motion to accept the letter as is and move forward, or something else?
We're going to need a motion that we adopt new 681.140 and that we repeal 141, 142, 143, and 145. Is that correct, Patrick?
There's also a corresponding amendment to 147, and it's purely just to make the outdated language match up with the new CE rule.
Okay. I apologize, I left that one off and including the amended 147, but I just wanted to make sure that these can all be done with a single motion as opposed to separately.
Yeah, that's fine. It could be one or it could be multiple motions. We don't need to vote on the governor's office letter.
Okay,
I move that we adopt the new rules 681, 140 and repeal those corresponding rules.
thank you, Janie.
I second.
Thank you, Dr. Alona. We now have a motion and a second. Are there any questions, any comments regarding the specific motion? Yes, Patrick.
We can take it up under a separate motion. It didn't, I don't know if Ms. Stubblefield's motion had the amended 147 in it.
Oh, and include the amended portion.
Okay, so just to be very, very clear, the motion is that we adopt new rule 681.140, that we repeal 681.141, 142, 143, and 145, and that we adopt the amended 681.147. Okay, at this time, we will go ahead and vote. Please, I want to be able to see everybody through the camera. So all in favor, please raise your hand to where we can see it. And that is all 8 of us, correct?
Yes.
Okay. Then since all were in favor, we do not need to note any opposition. Thank you. The new rules passed. Again, thanks everybody for your hard work on this. It was, this is a good result of a year's worth of work. Thank you. Moving on to letter B. We had Dr. Taylor came to the Rules Committee with some kind of pretty insightful thoughts. And after some discussion with the Rules Committee, we sent it to staff who drafted some language. And so we've got kind of an interesting new item here for the public member. I'm sorry, for anyone listening in on the Zoom. What we're going to do here, Dr. Taylor is going to explain why he came to the Rules Committee with what he identified as a need. Patrick is then going to explain how staff handled it and the proposal that came out of that work. And then we will move to public discussion for public comment prior to board discussion. So that's the order that we're going to handle everything. Dr. Taylor's going to start off with the introduction. Patrick is going to follow up with the lawyer product that came out of this. And then we will take public comment on our new proposed rule change following their discussion. So Dr. Taylor, explain to everybody your thoughts on this, why you came to the Rules Committee and your concerns.
Thank you, Mr. Chair. We have several rules that are proposed in this. Are you talking about specifically 681.35?
Yeah, start with that one.
I think that's the only one I brought in.
But that was the impetus for all that. So lead off with that.
Yeah, that's right. Yeah. So basically with the Patrick, or did they officially call it the Uvalde report? Is that what they called it?
I mean, it's I don't remember the exact title, but I think it was in response to Uvalde.
Yeah, essentially saying that we need to take a long look at our rules, which we plan to do after session when our annual rules review comes up, and look for any inefficiencies that we have, any gaps, anywhere that we can help bring more people into becoming a therapist, lessen the burden on therapists, make it easier for them to maintain employment, make it easier for them to work with people. So right before then, I'd already had several therapists reach out to me with just concerns about working for a new employer. And as the field kind of shifts from, I go and start my own private practice to now more employment and larger group practices or agencies or multi-state groups, mixed facilities, hospital systems, all these things. Several people had said concerns about how we were drafting the HIPAA requirements, the informed consent, that they might not have the ability to have control over that form, much the same way that we don't hold them accountable for maintaining records, right? If they work at an agency, it's not their responsibility to maintain their records, right? It's the agency's responsibility to maintain the records. And so this, we had a good discussion on the value of allowing an informed consent to exist that is acknowledged, but not necessarily with written consent if it was out of the individual's control. So staff kind of took it from there. The idea of this is to make it easier for therapists to continue to work at different agencies, at different employment settings, without concern of being held liable if they make a clerical administrative error. Obviously, the rest of the rules are still very much intact, so the licensee would still be held accountable for any malintent. But that's not what we're seeing, right? The therapists are not out there trying to harm people or trick people. But as they go to work for a larger employer, they lose control over their ability to draft the correct forms, to draft informed consents. And as the world grows more complex and we work towards bringing in the counseling compact, and we work towards more of a global mental health workforce, we're going to see more and more of this as we move forward. And so we definitely plan to do a full rules review after Senate, after session closes, and work towards finding more and more ways to bring accessibility into mental health care and open the field for even more therapists without watering down the integrity of the field, our education, our value, and those things. So this rule is just a small rule that is a small change, hopefully of many other small changes that we can make in the near future to increase accessibility into the workforce of mental health care.
Thank you, Dr. Taylor. Patrick, can you take what he introduced, what we discussed in the Rules Committee, and explain to the board the written legal product essentially that came out of that? You kind of point out what's new, and a lot of it is not new, but it got redistributed. Explain why, explain the reasoning behind the redistribution, and assure everybody of what did not change, what did change.
Right. So what Dr. Taylor's changed, the rule that we would need to change is 681.41, and it is one of the longest, if not the longest, in the LPC rules. And compared to even some of the other boards, I think it rivals some of the really long rules. So what we've tried to do is break up, whenever that happens, break up rules in sort of intuitive groupings, because what we, when staff is answering questions from either members of the public or licensees, and they say, well, what are the requirements for informed consent or billing or records? We'll say, well, it's in this rule, that rule. What my 2 cents is, we find that 681.41 is so long, people stop reading, a quarter of the way through, halfway through, when their answer is towards the end. And to me, it would make sense, and a lot of staff here thinks it might make sense, is to basically take what's already in the rule, but just break it up into sort of, it's their own separate rules. So there'd be their own sort of intuitive groupings. So what we did is you'll see in the packet, there's a lot of different rules, but it took 681.41 and broke it into multiple rules. So 681.35 is informed consent. And if you look, it's all underlined because it's technically a new rule, but all that language is identical to what's already in 681.41. The only difference is D is highlighted in yellow, so you can see that's the actual change. And that's the only substantive change. And that goes to what Dr. Taylor was talking about with informed consent. Now, there's a couple other highlighted parts in 2 of the other new rules.
Patrick, Sorry to interrupt. Is it possible for you to share the screen so that the public can follow along
Sure.
the rule? I think
Yeah,
that would be helpful.
yeah, let me,
Sorry for the interruption. Thank you. If possible.
yeah, let me see if I can do that.
I have it, Patrick, if you want me to pull it up.
Yeah, for 35.
Yes. You want 35?
Yeah, let's do 35 first. So yeah, so there's 35. So all of this underlined language, while it is underlined as new language, it is verbatim the same as what's in 40 in 681-41. Now, if Christina, if you'll please scroll down to the last in D. All of this is the same except for D. That is the new language that Dr. Taylor was talking about. So what we've done is broken them out into, there's an informed consent, a client records rule, a billings rule, a conflicts, boundaries, dual relationship rule, and then we're still keeping 681-41, which is titled general ethical requirements, but that's going to be significantly shorter, and it'll have whatever doesn't have, isn't that much to kind of put in its own separate rule. And that way, I think if somebody has a question about billing, a question about conflicts, they can go to that specific rule that'll be much shorter and specific to that issue, as opposed to a general rule that they're having to go all. I mean, I think we were getting into double lettering. There was a AA, BB, CC, and we were adding more to that. It just was getting unwieldy. So that was sort of the idea behind why we broke it out. And then the other two, Christina, I think there's two other rules where there are slight changes in 38. If you can bring up 38, 681-38. There, what we did was, you can see the yellow part, which is struck through, but we tried to do is just sort of reword it so it read a little odd, little strange, and so we're trying to have it substantively say the same thing. It just make it a little bit clearer. So it's those are purely for clarity purposes. Those, and I think 38 was one, and then the other one was in 36. I think was the other one where there's a highlight of a change. Yeah, right there. That's just try to make it more direct, a little bit clearer, and also trying to clean it up from when it was written in that other rule to make it fit into a newer rule. So, but I don't find, that those changes will actually change the effect of the rule or what's required by the rule. It's just trying to make it a little bit clearer to understand. So the only real change is, again, going back to 35D. That's the new language that's really being proposed that touches on what Dr. Taylor was wanting to address.
So Patrick, that letter D right there, that's highlighted, that is the bulk of a proposed substantive change.
Correct. Yeah, yes. And there are also some amended, the amended rules, 681-41, 681-52, and 681-205. Those are all just corresponding changes. If we make these edits, those rules have to have changes. I didn't address those, so I was just going to briefly touch on those. Those are all just, since we're changing the actual number of the rule. Thank you, Christina, on this is 205. The schedule of sanctions, then it said there's no longer a 41F, it's actually a 35B. So those are just corresponding changes that would need to be made if the board wants to go along with these proposed changes. Same as 52 is parenting facilitation. There's a quote, there's a reference to 681-41, and it's buried in there. Christina, sorry, it's towards the end.
I think it's the end, yeah.
Yeah.
Hey, Patrick, is this part of a broader trend with the other mental health boards of?
Yeah. Yes.
Of separate, I guess, kind of separating it in the interest of clarity, in the interest of making the rules more accessible? Is this kind of a broader trend that we are either following or we're kind of joining?
Yeah, yes. I mean, I know specifically I've spoken with the social work board about some of one of their rules in particular, and they were in agreement about breaking up one of the rules that is also extremely long. But the difficulty is breaking it up. So we're definitely trending towards trying to make it more accessible, easier to understand, so, and I think that this goes along those lines where you will have more, it's something that anybody can take a look at and they won't be overwhelmed by it, I think.
So board, when Patrick sent these proposed changes back to the rules committee, I kind of took it as, hey, Dr. Taylor, that's a good idea. We think that we should do that. So here's proposed letter D. But while we're at it, this is a good time to kind of, so we're putting like a new tire on the car, but while we're at it, we're going to go ahead and rotate all the tires. And we're basically, they're using, so we have this key addition, but we're also taking the opportunity to make our rules more effective, to make them more accessible. Right now, it's a big pile of ethics requirements, and now we sort of separate them into handy categories. That's the reasoning behind this. But it ended up being a little bit more than we thought. But I think I agree with Patrick, is if we're going to be making this one little substantive change, it is a good time to kind of tackle, especially in line with the fact that the other mental health boards are also doing the same thing. So that's how we ended up with the proposal that's in front of you today. Okay, so we are going to have board discussion on this, but at this time we're going to go to public comment, and it's going to be limited to just these proposed changes. So Christina's going to see if anyone has public comment on this. Following public comment, we will have a board discussion. So Christina's going to take over for a minute. It's 3 minutes, the usual 3 minutes, this discussion. Brenda, will you be the timekeeper, please? Or is it Brenda or?
Patrick, you want to do that?
Apologies.
That's all right.
All right, so anyone who's interested in public comment on these rules, please raise your hand in the Zoom function, and I will open it up for you to speak. The first person that we have is Rhonda Kimball.
Good morning, everyone.
Good
So
morning.
as you're speaking, I'm hearing that the problem is that the counselor is being held accountable for consents to the organization. And so that's the problem, and the solution would be there wouldn't be so much liability on the counselor. If that's what I'm hearing Dr. Taylor saying. For some reason, you mentioned Uvalde report, and in my mind, I'm thinking informed consent in a crisis situation should be considered as well. Okay, and also because you're talking about HIPAA and informed consent, I'm wondering if you're taking into consideration the exposure, media exposure, and things like that. Because if the counselors are being held to an informed consent in crisis and compact situations, we're not always in control of the client or the victim's exposure. So when I'm reading this and you're talking about informed consent, I would like you to consider those things. And HIPAA is always having to do with disclosure. When you make reference to these other safety codes, it'd be so nice, like I said, safety code 611. I don't know what that is. I know this is what you guys do. You spend a lot of time on this, but I'm your public, I'm a professional, and I'm listening. I'm going, what are they talking about? This is a lot. And I love that you put the codes up today, the rules, but it's a lot and it's going really fast. And as much as I like to think I can, read and comprehend everything you're saying, it's fast. So consider your audience when you're presenting this. So 1 is presented and now 10 are presented, and we're supposed to digest this and then have this really quick vote. And I don't think that serves the professional. Okay, so you talked earlier about, regulating the profession. That's one thing with the CE business, but regulating the professional needs to be looked at a little bit more carefully as you are our board, and we need you to advocate, not just protect the public, but to also advocate for us and make sure our liability is down, so our insurance stays down so we can serve, especially as we go into other fields of, this compact or working for big hospitals and whatnot. To consider us, our exposure, and having to come before boards because of different accusation. Thank you.
Thank you, Ms. Kimball. We appreciate your time. Just so that everybody is aware, this is a vote for a proposed rule. So you will have ample time to review. You'll have several months to review it in the public register when it's published, with all of the rules printed out and clear for you so you can see the adjustments where they are. Then after public comment is received, we'll come back and re-review the rules. It still has to go to BHEC as well. So there's a long process for reviewing this. So you'll have plenty of time to review everything. And the Uvalde report that I was mentioning was a review of not the incident that occurred, but the issue of the lack of mental health support in that community. There's just a small portion of the report. The report is very large, but that is focused specifically on what can we do to increase our mental health workforce, not so much the crisis specifically, just for clarity.
Okay, next person I have is Sandra Martin.
Can you hear me?
Yes.
Okay, well, first of all, I want to say I appreciate Rhonda Kimball's comment. I think it was well ordered, and I particularly appreciated consider the counselor in the complexities of the rules. And I hear that happening when I came into counseling, state license counseling. I always heard the board is not your friend. And I thought, well, that's not a good thing to be telling us that we need to have a friend. And I find, as I'm also new for Christian Counselors of Texas governmental liaison, we haven't had one before. I'm finding that the counselors want to understand the rules, but they give up quickly on. And so I would support Rhonda in her question about please consider your public, and please, as much as you can, make it readable, and as much as you can break it up into smaller pieces. It certainly helps me talk with the people in our organization, and it helps me understand enough to talk with them well. So thank you, Rhonda, for a good comment, and thank you, board, for what you're doing now. I see a move forward in that's going to be very, very helpful. Thank you.
Thank you, Sandra.
And next I have is Angela Bowles.
Good morning, board. My name is Angela Bowles. I am the TCA liaison and a licensed professional counselor supervisor. TCA would like to share that the updating of rules at almost every meeting seems to be creating a challenge for licensees. While we appreciate the increased communication of the diligent work of the Rules Committee, the consensus seems to be that the rules are constantly being changed, placing a serious burden on the licensees and consumers to know exactly what rules are currently in effect. We see significant amounts of conflicting information on group listservs that misstate rules. TCA recognizes the importance of rules being appropriate, but would like to ask the board to create a schedule, perhaps annual, to review their rules and propose changes. It might also be helpful to add information about the process of changing rules, a Cliff Notes version in writing for licensees who are unfamiliar with the process. Now that meetings are online and recorded, everyone has the opportunity to stay current, and hopefully this has helped increase the number of people who can attend. So perhaps the challenge is keeping up with where a rule is in the process and when changes take effect. Is it possible to continue the engaging dialogue about the rules throughout the year and set a fixed meeting date to present all rules moving forward in the process to take effect on the same date? Thank you.
Thanks, Angela.
And next I have is St. Mark's Host is the title.
I apologize, I didn't get the name changed. My name is Iona Olive. I'm just a member of the public. Not a counselor, not in that profession, not in the mental health profession at all. I was not going to speak, but having heard exclusively from counselors so far on this, I just have to say I appreciate that there is a board that isn't there to be a friend to counselors. If we look through the orders in this set of public meeting materials, we see somebody who is sanctioned for having child pornography. Every time I read through these board packets, there's some kind of sexual misconduct. So it is really important to the public that they have a board that is not on the side of the professional who may have violated ethical standards. So I appreciate the need for them to be comprehensible. But that I do not believe that is the purpose of the board, and I think y'all know that very well. So I'm just here to say there are very good reasons, especially for parents of children who may be treated without their consent, that kind of thing. So I just think it really needs to be clear that the board is there to hold counselors accountable for on behalf of the public, who their only recourse otherwise would also be to hire a lawyer. And that is not usually something that is, or often it's not something within the means of somebody who is seeking recourse for their child or themselves to advocate for unethical treatment. And that's all.
Thank you for your time, comment. We appreciate you. Just a reminder, the chair did ask that we hold these comments to 8B in the agenda, specifically those rules being proposed. We will have time later for an additional public comment for more philosophical debate on what the purpose of the rules are, if we would like.
And last person I have is Jan Fries.
Good morning. I'm just going to be really quick. I do support the comments that Angela made about constantly changing rules. It really is a problem. And Dr. Tiller, I think that's relevant to this discussion as well. I would also say that given that TCA would, we haven't vetted all of our members on this yet or leadership, but I feel we would support the addition of the new language. TCA receives multiple requests from both agencies and individual practitioners working for agencies requesting clarification about who is responsible for securing informed consent, maintaining the records on informed consent, maintaining the records for their overall practice and interaction with clients they see through government agencies and so forth. So I do think that this will help to clarify that. But again, change in rules at every meeting, and especially with the arduous process that now we have with having to go through BHAG and multiple publications in the public register, it's really challenging for people. And when TCA has been asked to create a summary, I'm not really inclined for us to do that, as we can't speak for you on the rules. I prefer to direct people to rulemaking process. So thanks for your consideration, and thanks for all of your hard work. We recognize you're all volunteers.
Thank you, Jan.
I have no other comments.
All right, thanks, everybody. We will now go into board discussion on this. Dr. Taylor, you want to start us off? Just kind of explain where you were coming from on this and how you do view this as, to say that something is pro-therapist would almost imply that it's anti-public, and that's certainly not the case here. But this is what you view as a recognition of new technology that's affecting the way that mental health services can be delivered, and the fact that it does sort of put a therapist in some situations at a disadvantage of having to make sure all of their paperwork is in order, and it does put them technically in violation of a rule as written. And so we are trying to create something that does protect our therapists from getting crossways with the rules, without creating a risk to the public. And that's how I took this. So if you want to add anything to that, please do.
No, Mr. Chair, that sums it up along with Jan's comments as well. I think that was at the heart of it, was we don't want licensees or associates being, punished for things that are outside of their control while they're just trying to help people and be good therapists. That seems to be in line with some of the direction we'll be getting from, I believe, the state Senate in this session, and what we'll need to be doing moving forward. So.
Thank you. Other members of the Rules Committee, how do y'all feel about what came out, or what the new language that came out of our committee meeting? How do you feel as though the language addressed the points that we brought up in the committee meeting?
Chair Hobart, a lot of our discussion was actually, this gives the individual therapists that responsibility back to be able to do it, but not just inside a box. That if they have the ability to control the paperwork and have their name and any, information, like if you are an associate, you need to have your supervisor on there. But if you are in an agency and somebody else has done an intake and they've passed a client on to you, then you still have that responsibility to share any information regarding your license with the client in front of you. It just doesn't have to, we don't want it just to be so rigid that it can only be done that one way. So this is opening up opportunities for people to follow the rules, but not only one way.
That's a good way to put it. Thank you, Janie. Brenda, did you have something to add?
I do. And I agree with Janie. I think that having worked for employers, also being self-employed, there are different options, even when you are documenting, a verbal consent to have virtual session, or informed consent, blah, 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 those kinds of things. So you still are able to document and being somewhat in control of that as well. I wanted to say also that I understand that oftentimes the public is hearing constantly the rules changing and trying to keep up with that. And the only thing that comes to mind for me is the board is on a mission to provide the clarity, the transparency that the public needs. That's all we want to do. We don't want to, give you extra homework and constantly be on your toes about changes and what happened now. And just always remember that, we're about being honest, transparent, and making sure that you understand what's written and that you have these opportunities to come and give us that feedback, and we welcome that. Thank you.
I agree, Brenda, and it is these rules and the pace at which we have accomplished them that has removed our backlog of complaints, that has removed the 3 to 9 month waiting period for licensure upgrades. So while I appreciate the concerns of changing rules and consistency, the reason why I'm here, the governor appointed me to ensure that we have the best system possible, and I plan to do that.
Thank you, Dr. Taylor. Brenda, kind of echoing what you said. Yeah, we understand the concerns about constantly changing rules, and I get that. We'll try to do a better job of that. But I would want everybody watching this to understand that we only bring up these rule changes if we believe that they're necessary and that it's a good change. And I realize it seems like we're constantly talking about rules, but that is a bit of the nature of the system that we have now, being that things go back and forth so many times. For this one that we're discussing right here, please separate discussion about the rule itself, the proposed changes to the rule itself, separate that from a broader discussion about how often we discuss the rules. Okay, so when you comment on this, and going forward when you comment on it, please comment about the substantive change itself. And then we will leave how often we discuss rules. We'll leave that to a separate discussion. But for today, we want to know how you feel about the proposed rule itself. And then we will have a different separate discussion about how often we discuss these rules. So board, I'd like to hear from you now. This is your first opportunity to kind of let us hear how you feel about the proposed change. Do you think that addresses a problem that once you think about it, you understand, oh, I do see where somebody could run afoul of the rules. And so I think that this change does keep them out of trouble with the board, but it's not a change that is going to create a material risk of harm to the public. So Dr. Muna, take it.
Absolutely. I mean, I'm thinking I would much rather be proactive than reactive. And as a board, a lot of times we find ourselves in reactive situations just by happen chance. I'm thinking about what's on the horizon, interstate compacts. With regard to companies, I think Brenda and Dr. Taylor mentioned, sometimes individuals may work for an agency that's not even in our state, that may do all of the intake paperwork for them. And the only thing that they have control over is the session and their note from that session. And so if the paperwork is not done from insert internet global health provider, right? I won't say a name. But if the paperwork is not done correctly prior to that licensed person seeing the
Dr.
client.
Muna, I find it highly ironic that you mentioned a large, oh no, that's me.
That's what I said. I didn't say a name. I didn't say any name. But in the concept of an interstate compact, knowing that our licensees have access to other companies, other corporations all over, you don't want it to be where I'm just trying to do the good deed of helping people, and the coordinator who referred this person to me didn't get the paperwork done. Now my license is in jeopardy because I didn't have control over the informed consent. But what I can do, even if it's virtual, say, hey, I just want you to know, these are the things that we have to cover regarding informed consent. And then in my note, I have that power to say, verbally went over informed consent per my board rules. That is gonna save you a lot of time. And I think this new change is going to help. It's going to help clinicians, but it will also help them help more people without worrying about the liability of, I never saw the informed consent because the person was just referred to me. They don't have that worry. They can just do the job that they're passionate and they've been called to do.
Thank you, Dr. Amuna. Dr. Bradley, do you have some thoughts on this?
The only thought that I have is kind of what other people have been saying. I think it's important that we give the public time to see these rules, and our process does that. I think it's also important that we solve problems before they occur, and I think this process does that. So, I think that we have some good ideas here.
Thank you, Dr. Bradley. Public members, I always like the way I approach these as a public member. I ask myself, if I just looking at it from the outsider perspective, would I be concerned that this proposed change creates a risk of harm to the public? And so I took a look at it. We discussed it in the rules committee. I got to a point where I felt satisfied that it does not create an significant or material risk of harm to the public. But I want to know if you got how you guys feel about it. So Vanessa and Pastor Roy, let me hear your thoughts on this one. Go ahead.
Well,
Vanessa. I'm sorry.
I concur with Dr. Amuna and the rest of everybody. I think it helps. It's in a proactive manner, and it will help navigate both the clinician, the professional, and the public as well. I see no place in it that really that gives me concern at all.
Thank you, Pastor Roy.
I
Vanessa?
totally agree. I agree with the assessment as well. I don't feel unsafe as a public person if I were a client. I don't feel unsafe with it. I feel it's very clear. And I don't think it infringes upon anyone's safety or a lack of protection. I think it's a great thing to incorporate.
All right, thank you. Dr. Taylor, this was kind of your creation. Do you have anything else that you want to mention that we haven't discussed so far? This was like people keep using the word proactive, and I think that's a good way to describe it. To your credit, you identified what you believe is an issue that's going to be, we would see without a rule change, we would see more often moving forward. And I think why you brought it to us is you believe that the proposal was a good way to kind of address these potential concerns before it kind of became an even larger issue. And then our task would be to be kind of cleaning up a mess as opposed to getting out in front of it, establishing a good change prior to where it really became a problem. That's how I took all this.
Yes, Mr. Chair, that's correct. I feel like we are, at least I'm ready to move forward if you are.
All right. Well, if there's no longer general discussion, we'll need a motion on whether we want to accept the proposed and amended rule changes 682 681.
So
I'll
moved.
motion- oh, Go ahead,
So
Brandon.
moved.
So moved.
Okay, Pastor Roy made the motion. Do I have a second? And Dr. Amuna seconded. Okay, so we do have a motion and a second. The motion is that we accept the proposed rule changes as written to 681. Patrick, do we need to list the subsections for the motion?
I think you could just say in 8, all of the proposed changes in agenda item 8B, and they're all listed there.
Okay, the motion is to accept the proposed rule changes listed in agenda item 8B. So any discussion regarding the motion? Okay, hearing none, at this time we will vote. Again, I will ask that you raise your right hand so we can see everybody on camera for the record. All in favor of approving the proposed rule changes, please raise your hand. Thank you. That is all 8 of us. Seeing that it is an 8-0 vote, we will not ask for any in opposition. Patrick, just a quick little just reminder to everybody watching the Zoom today, or will view it on YouTube, kind of explain the next step in this, where we go from here, and everyone's opportunities to let us know how they feel about it.
Yes, so both of these that were voted and approved, 8A and 8B agenda items, that will all of those will go to the Behavioral Health Executive Council's meeting on January 31st, and they'll get reviewed there as well. And if
Not 8A, 8A is done, isn't it?
well, no, 8A still needs to get approved by the council.
I know.
The council will publish the final rule in the register.
Okay.
So that'll need to go to the council has a meeting on January 31st. And they will review and hopefully adopt all of these as well. And so for 8A, if they adopt everything, it'll get published in the register, and those changes will be effective. The 8B will also go to the council and be reviewed on January 31st. And if approved, it typically goes to the governor's office for some review, and then it goes once finally approved, it then gets published in the Texas Register for public comment. It will get reviewed January 31st at the meeting for 8B. If anyone wants to make public comment at that meeting, they certainly can on any of the rules being discussed at the meeting. But then going back to 8B, once it gets published in the register, they can file formal public comment, written public comment to it, which will then get reviewed again as well. And that'll once the public comment period closes after 30 days, that'll come back to this board to review those comments and the proposed rules, and then make a recommendation again to either adopt, amend, not move forward with it, and the rule changes, and then that will go to the council again for as 8A is being reviewed. So it's a two-step process as opposed to just going from the board to the register. It goes from the board to the council, then the register for each of the steps, whether it's proposal or adoption.
Well, Patrick,
And they can comment at all the meetings as well as submitting written public comment. Sorry, Brenda, I cut you off.
oh, that's all right. Just for proposed rules, there is just that one extra step going to the OOG for approval.
Okay. Thank you, Patrick. All right, let's keep moving on. Agenda item 9 is committee reports. The only committee that has met since our previous full board meeting was that Troublemaking Rules Committee. And you already got the gist of what came out of that committee meeting. Is there anything that I missed that that the committee members want to bring up that came out of that committee meeting? No, okay. Hearing none, we'll go ahead and move on. Item 10 is the board chair report. A few notes that I want to make for you. First of all, the new legislative session is underway. There's all sorts of flurry of activity going on over there at the Capitol. One key bill that has been filed is Senate Bill 47 and its companion bill, House Bill 1167. This is identical to the bill that was filed 2 years ago that nearly passed. It's related to the licensing of out-of-state applicants. It if I recall correctly, it eliminates the verification requirement on the 3,000 hours of supervision. Like I said, it is identical to the one that nearly came so close to passing 2 years ago, but did not quite get over the finish line. But it's one that we will be watching with interest. Hopefully it does make it through this time. It's a good bill. We felt as though, our position is always the proposed bill. The board feels as though the proposed bill would benefit the citizens of Texas. And that's how we feel about this one as proposed right now. As of today, there is not a counseling compact bill pending in the legislature. So we are optimistic that there will be one. We're hopeful that that does get moving. Again, anybody that might inquire about how the board feels about the counseling compact, we would, of course, direct them to the resolution that we passed and our reasoning for why we believe that the counseling compact would benefit Texans. BHEC, we have not had a BHEC meeting in between today and our last full board meeting. So there's not a lot to report out of BHEC. The next one is coming up on Tuesday, the 31st. We do have some good news out of BHEC. Daryl shared with me that frankly, the first quarter performance measures were actually looking pretty good. To share with y'all briefly, first quarter of fiscal year 23. Altogether, BHEC has issued over 2,400 licenses, has renewed over 7,000 licenses, resolved 209 complaints, has only 413 complaints pending, and is processing applications within 37 days. Complaint resolution is now an average of 288 days, and 60% of those complaints are being resolved within 6 months. Altogether, BHEC now has 80,000 licenses under regulation. Those licenses are held by just over 74,000 individuals, and this is all being regulated by approximately 60 staff members down here in Austin. So on the BHEC side of things, for an organization that was created for a legislative session of 4 years ago, the end result right now is very positive. It's going well. Daryl was unable to make it today, but I think he'd probably add on to that. He would echo those statements. Staff, is there anything that you guys would want to add to that? I'm trying to sing your praises here because I believe you guys are doing a good job, and I encourage you to keep it up. And we're trying to keep the LPCs from not being the problem creators for VHEC. So Christina or Patrick or Brenda, anything to add to those statements? I wanted to give you guys that shout out. All right. Next, since we had our last full board meeting, a few of us got together at the TCA Professional Growth Conference. I'd like to thank the board members that joined our panel presentation, Ms. Janie Stubblefield, Dr. Leah Amuna, and our esteemed panel moderator, Dr. Christopher Taylor. Dr. Bradley, we missed you, and it was disappointing that we weren't able to see you there. However, I'm glad that you're doing better, and we hope to see you for the next one.
Thank you. I had food poisoning and could not travel.
Yuck. Well, I'm glad you're doing better. I wouldn't say that I filled in for you because I just kind of sat there. But you were missed. But thank you. It was nice to meet Dr. Amuna in person for the first time. And it was nice to see Janie for the first, what, been about 2 years? So it was nice to meet Dr. Amuna. Janie, good to see you again. Dr. Taylor, I see you way too often. But those of you that I have not met in person, I'm looking forward to it someday soon. So thank you for joining us at the TCA conference. And one last item, Janie came forward and brought us an idea for a new lunch and learn topic, and I'm going to hand it to her to kind of explain what she'd like to do, and kind of if I understand correctly, we have a last minute update and that we have actually set a date for this.
Dr. Muna, do I have a thumbs up? Okay, so one of the ideas that I had for a lunch and learn for our professional counselors is on cultural awareness. And so Dr. Muna and I are going to partner. It will be in late April. And the date that we just hot off the presses is going to be Thursday, April 20th. And this will be at lunchtime. It is no cost. It will be via Zoom, a Zoom webinar. And so we're working on a training on cultural awareness so that, just to help us in the professional counselor, because we all have a variety of clients that come to us, and helping us be culturally aware as we serve a culturally diverse population. So very much looking forward to working with Dr. Amuna on the project.
Thank you. That's all I had for the board share report. Any questions? Okay, hearing none, we will go ahead and go to the board administrator, Christina.
All right. So we continue to receive a high volume of phone calls and emails. Staff are doing pretty good at handling those quickly. Those who are submitting their inquiries using the contact us form. That's the best way, because then that email is sent directly over to the staff member who is handling that type of inquiry that you're reaching out for. Please remember that there's a lot of information on the website. So if you can try and find answers there, we try and keep up with our Q&A section. We add things periodically when we're seeing a lot of questions come in on the same type of topic. We'll throw a new Q&A in there. So check those every now and then. Also on the board, on the email, I'm sorry, on our website, I wanted to just share screen real quick with you guys. The biggest thing, remember to sign up for email updates and pass the word, because it is so important. I know people are talking about, keeping up with rules and all that good stuff. So Maine BHEC website, you can go to Google, you type in BHEC or Texas Behavioral Health Executive Council, will come up, our link will come up there. On this Maine BHEC website, there's a email updates. You just click there, sign up for whatever, program you want to, and you're going to get any email blasts that go out that of anything going on with the board. So it's very, very, very easy to do. So please do that. And again, share this information with everyone that you know. And then also when you click on our specific website for the LPC board, the very first link on the right-hand side is board news. This is a really, really good spot to check in on also. This is where we have all of our information about public comment, and anything that's posted here is also going to be sent in that email blast. So make sure, and again, sign up for those email updates. But when we have new proposed rules, when we're, requesting public comment, when there's new rules, when we had the meeting date, this meeting date changed from the previous week. So it was put on here, and even the lunch and learn that Janie was just talking about, we have all that information here, and we, any presentation that might be there, it's all linked here. So we're trying to put as much information that's helpful to you all on the website. So please, go through it, and it should be there. So I just wanted to show that to everyone real quick. Good news for the program, we do have a total of 5 full-time staff now, which is amazing. So timeframes are, right now they're working on January 1st for new licenses and out-of-state licenses. Upgrades, they're working on January 12th, as well as supervisor applications. So staff have learned every part of the program. Previously, it was, one person assigned to initial apps or one assigned to supervisors, but now they're cross-trained all the way around. So the program operations are just working excellent. Just a reminder about deficiencies. If you apply and you get a deficiency, you're going to get an email. It may come from do not reply. Make sure and check your junk mail. Supervisors can continue to add or drop their associates using the online portal, but the associate must continue to use the online upgrade application. No fee, they just attach their SED there. So let's see, if you're selected for audit, we do send out a letter now also within that 60 days before you expire. So that's going to be your, hey, alert, I got to get my CEs uploaded onto the online renewal so that we can avoid any, delay in your renewal of your license. If you fail to do that and your license does go expired, you cannot see clients. You do not have a valid license. So make sure and don't wait till the last minute. Again, we send out that courtesy renewal and it's ready for you to go ahead and renew 60 days before that license expires. So we still require the human trafficking CE for each renewal. It's on the HHSC website, so that's definitely something to continue doing. The jurisprudence exam, once these new rules that we talked about today are official, because there still has to go through some steps. Once these are official, the jurisprudence will be required at every renewal. Currently, we don't require it at every renewal, but it counts, for 1 hour of ethics. But once these new rules that the board approved today are, adopted, then we can go ahead. You will be required to do the 1 hour of jurisprudence exam each renewal. Fingerprints, they must be for our agency. This is a big one that our renewal coordinator is seeing. Even if you took it for another license in another state or another profession, whatever it is, we cannot accept those. You have to be, it has to be with our agency. So just continue and do that, share that word too, because it seems like that's the biggest holdup on renewals is getting the fingerprints done. Otherwise, for enforcement, we currently have 20 cases being monitored for compliance, and currently they are all in compliance, which is great news. But other than that, that's what I have. If the board members have any questions or anything that I may have forgotten to try and get the information out, let me know.
I just want to, go ahead.
No, I was gonna say, any questions for Christina? Go ahead.
I just wanted to say thank you and sing their praises for the work that they do. As a board member, as a licensee, I just want to say thank you. I think there are a lot of things that they do after hours, during work, to help people as much as they can. And I think our board meetings don't cover all the background work that they have to do to help us do the work that we do. So I just want to say thank you.
Absolutely. Any other comments or questions? Go ahead, Dr. Taylor.
Just that your staff is just rock stars. So keep being awesome. Thank you. I know Victoria and Kenneth, we've been working hard as well to get those cases resolved. So let's keep going.
Okay, thank you, Christina. Let's go to number 12, general public comments. Same rules as always. You have 3 minutes for public comment. Christina is going to quarterback this. Go ahead.
Yes. And I believe your name was Iona, if I remember correctly.
Yes, that's correct. I apologize. I couldn't change the name once I joined. So.
That's okay.
So I just wanted to clarify, and I apologize that I wasn't as focused when I commented earlier on that specific rule, but my encouragement would just be to, in further discussions in terms of 681.35, informed consent, and that section about having counselors be able to get that verbally if they're working for an agency, that's what I understand that to be. And I would just like to hear in further presentations of that discussion and consideration, what risks have been considered. I heard a couple of public members of the board say, I don't feel at risk of harm. I have one consideration for that, which is, like I said, specifically regarding parental consent. I think every quarter I see at least one order that has to do with a counselor providing counseling to a minor without obtaining court orders or following court orders, whether with this board or one of the other boards. And in general, I would say that my experience with this over a very difficult family situation is that especially larger institutions, but also counselors as a whole, do not understand family law particularly well. It's not their job to necessarily. I'm not criticizing them for that, but it's a potential risk that I have seen borne out in a lot of harm done to a child. So that's my concern. I would just encourage you to think about at least outline what other risks were considered and how those are being mitigated, and whether or not there are potentially other solutions to keep counselors from being complained against for this, but without putting children at risk. So that's kind of how I just wanted to clarify that. And I apologize I wasn't more focused about that earlier. Thanks.
Thank you.
Okay, next I have is Angela Bowles.
Good morning, board. My name is Angela Bowles. I am a licensed professional counselor supervisor and the Texas Counseling Association liaison to the board. We would like to thank the board for presenting and having a booth at the 2022 Professional Growth Conference. We always look forward to opportunities to interact and engage with the board. So thank you so much. At this time, TCA is requesting clarification regarding the LPC associate title. We are seeing more and more people using an abbreviated version, LPCA, when it is our understanding that the correct legal title set forth in the code is LPC Associate. The inclusion of the full word associate is intended to provide clarity and therefore protection to the public by letting them know these counselors do not yet hold the full privilege to practice independently as an LPC. As always, we would like to thank all members of our volunteer board for their time and dedication to helping us serve our fellow Texans as professional counselors. Thank you. We hope to see you at the TASES Midwinter Conference, March 2nd and 3rd in Georgetown.
Thank you, Angela. I can clear that up for you. So the rule does read licensed professional counselor associate. So it needs to be spelled out. However, we did direct staff to take into consideration if a complaint is filed against an LPC associate, if that associate say works at a hospital or has a Psychology Today profile where they're unable and it's unreasonable for them to have associates spelled out, meaning they don't have control of how a name badge is printed for a massive hospital system, to take that into consideration. But you are correct. It is to be spelled out. So if they have a business card, they're starting their own practice, they have a website, they have informed consent that they are in control of, they should in fact have the term associate spelled out, and their supervisor should follow them relatively quickly with similar. We changed the phrase to be similar font. So they can't make it like 1-point font, right? But we're not saying it has to be identical, so that should clear that up for you, hopefully.
Thank you, Dr. Taylor. Next.
Okay, next person I have is Diane Smedley.
Good morning, board members and staff. My name is Diane Smedley, and I serve as the liaison to the LPC board for the Texas Association of Counselor Education and Supervision. I'm grateful today for the opportunity to provide public comment on behalf of TASES. TASES acknowledges the thorough efforts of the board, especially the Rules Committee, on continuously reviewing, streamlining, and amending board rules. As we've talked about today already, however, as of late, the frequency in which the rules are currently changing creates confusion among licensees. This confusion leads to unintentional misinformation on the part of licensees, supervisors, and counselor educators, and creates the potential for unintended harm to public consumers. Rule changes are important, and the ones like the ones y'all proposed today, I should say, are in the best interest of the stakeholders. Those were good rule proposals today. However, with the addition of BHEC, the process of rule changes has increased in ambiguity. In fact, we even heard some confusion among board members today on the rule process between board and BHEC in reference to 681, to the CE requirement changes, sorry. So licensees need a primer and guidelines to the new back and forth nature of the rule changes. And additionally, we do request a reduction in the constant frequency of rule changes to lessen the overwhelming hardship for licensees and frankly, to allow us to catch up. However, on a much lighter note, I do want to thank the board for their willingness to present at the TASES Midwinter Conference upcoming in March. The conference will be held March 2nd and 3rd in Georgetown, just as a reminder. And we do currently have the board speaking on Thursday, March 2nd at 10:30 a.m. I have been working with Ms. DeLuna to finalize the logistics of the board's attendance, but just remember, if you need anything, always feel free to reach out. Otherwise, TASES recognizes the board's continued efforts to improve the experiences of all stakeholders. We appreciate the board's volunteer time, consideration of public comments, and service to the citizens of Texas. Thank you.
Thank you, Diane.
Okay, next I have is Rhonda Kimball.
Hi, everyone. First, I want to speak to Miss Iona. I'm so sorry. I had a terrible personal experience with a counselor who was a deviant to the rules. And what I thought I heard you say is there was some criminal act. We as counselors, and I am a licensed counselor, so I'm in the field. I want you to know that there's always some bad apples in any industry, but most of us have spent a fortune and given a lot of time to help people. that are losing their hope and that are in predicaments like we spoke of, a custody battle. So please be reassured as we speak to our board for taking an advocacy position for us. I'm not asking for a friendship. I know the rules that I committed to, and they're not to break the law. And I want you to be reassured that most of us want to uphold the laws. And that's why we attend these meetings, and that's why we serve the public. We're not asking for favors, but we are also asking to have a voice and not be used in custody battles. And then our licenses are in jeopardy. So please understand that position, and my apologies for your personal experience that you mentioned. To the board, as you're talking about these CEs, again, you know, diversity, if somebody wants to take that, that's great. What I would like to see as a CE offered by you is this note-taking business to be in compliance with HIPAA and everything else, but also taking into consideration cyber crimes and the compromise of the confidentiality from our position as licensees, to educate what has to be as we get into this corporate mental health machine. We need to know what we are accountable for on those electronic notations to protect us. So I'd like some clarification on that from the board in the form of a CE. When you are changing these rules and we look at those numbers, I would like a little subtitle using the same language that you're using in these board meetings. For example, today, informed consent is what you're changing so that we know what exactly the rule change in particular is referring to when we go back in a less formal capacity to read it, so we can get the cliff note of, oh, that's the one they were talking about. Yes, that says what they said. Great, I know what to do. I also want you to consider a grace period. So you change the rule and someone gets accused of something and we say, oh yeah, but we changed that rule last week. Were they informed? Did they know? You know, sometimes people can't make these meetings. So to consider some kind of grace period between all these rule changes, and because accountability is heavy on the counselors to try to remember these things. I can't wait. Next year, I've got to do this jurisprudence. I got to see at 60 years old what I can remember. Thank you.
Ron, I appreciate that. Just for clarification, this is a proposed rule. It will go to public comment. All of those things you requested will be in the public comment packet. Then it goes to Behavioral Executive Council for more public comment. Then it comes back to us for more comment. Then we vote on approval. Then it gets approved. So we're talking 6 to 12 months from now. Then there will be a 90-day grace period before it actually is published in the register for everyone to view. And all the while, every time we do that, we do send out an email to everyone that's subscribed to the email updates, which is why it's so very important that everybody gets on those email updates.
And every time there's a rule change, the rule books are updated. The rule books they're found on the website, and they have the date of the change. So just keep an eye out for that as well. And next person we have is Sandra Martin.
Can you hear me?
Yes.
Okay, good. I've kind of scribbled some notes I want to state on behalf of Christian Counselors of Texas, as I am their governmental liaison. And I mean scribbled, so I hope I get them in the right order. Since the issue of our statement, the public is not your friend, that tends to be at our end of the relationship. The public is not your friend, the statement goes. It is here to protect the public. As therapists, I'll make that plural, we are here to protect and care for that same public. Sometimes the relationship with the public or with the board becomes broken. Following my notes here just a minute, becomes broken. And certainly when that relationship at any end becomes broken, it needs to be either repaired, or if not repaired, then ended. But on behalf of Christian Counselors of Texas, the relationship is never desired. That is one of perpetual animosity. evidenced in fear, anger, etc. The perpetual goal on our end is always for that relationship to be prepared and never for perpetual animosity to be the goal. A little too wordy in places, but I needed to say that on behalf of our organization. Thank you.
Thank you, Sandra.
Okay, and the last person I have is Jan Fries.
Hi, welcome. Thank you, board. Again, Jan Fries, CEO of the Texas Counseling Association. I just had one thought going back to the whole process and the confusion about rulemaking. Some time ago, Daryl had provided me with a sort of a summary of the rulemaking process. And I'm just wondering if maybe the staff, if you could create like a little infographic, right, that could be put up on the rules section. I think that would go a long way to help people understand the process, because people, to the point Dr. Taylor made, I think people really get confused because it is a very long walk from today when a rule is being considered by this body until, a year, 18 months or so before it finally gets adopted. So I think if we had some sort of infographic with some time ranges in there, I think it would really help, especially licensees who are doing their best to stay current on the rules. So that's all I would say. And of course, again, thank you very much. And again, I want to give one more shout out to Chairman Steve Hallbauer, who, as you all know, did receive the TCA Professional Layperson Award at the Professional Growth Conference for his outstanding work. So all you public members, keep it up. Next year could be your turn. Thank you.
Thank you, Jan.
Golf claps all around for our. Jan, would TCA be willing to create that? I think asking the state to make an infographic is probably going to break the government. So would TCA be open to drafting something and then we can review it for approval? I will take your silence as yes.
No, don't take my silence.
Okay.
The leadership of TCA has been having significant conversations about how best to do that, and we are a little concerned. I certainly will consult with Daryl about that process, but we oftentimes people confuse the Texas Counseling Association with the licensing board. And we try very, very hard to keep that really clear and distinct. So I certainly will visit with Daryl to see about the potential of collaboration, but honestly, I think that's something more appropriately coming from you than coming from us.
I agree with the information, but putting it into an infographic,
I feel like there's something that we can come up with to help clarify the process, but yeah, if I'll talk to Daryl as well too, and I'm sure Tim might already be working on something, who knows? But yeah, I think it's something that we can probably look into.
Chris, I'll have my daughter put together a TikTok explaining everything with a Taylor Swift song playing in the background. But I'm not sure about TikTok, but yeah. She can knock that out in about 8 minutes.
Oh, no, we're not allowed to use TikTok anymore, remember? Yeah, we can't touch it. Can't be a part.
Okay, it'll be on.
I don't know.
Okay. We'll put it on YouTube, but I guarantee it will have a Taylor Swift song playing in the background.
Oh my gosh. It looks like we have one more public comment, and this is going to be from Philip Crum. Are you there, Philip? Let's see.
There we go.
There we go.
Philip with practicemenders.us and the Association for Mental Health Professionals.org. Tim Spears on the BHEC staff actually created that document about a year and a half ago. We took that and actually embellished it and included in some of our materials, the workshop materials. So that's been around for quite a while. As to my next thought, I joined the meeting late, so I hope I'm on topic here, but the public disconnect with the board, I'm not sure exactly what we were referencing, but my initial reaction to that is we spent most of last year really fighting tooth and nail the CE renewal requirements changes as not being necessary in the first place, not having a problem to fix. And I think a big part of the disconnect comes from rallying the troops to be heard. And we weren't really looking for changes, or as I like to phrase things, putting different colored lipstick on the same pig when the pig was not necessary in the first place. That disconnect that exists, or at least the portion I live in, the disconnect is when this entire lengthy rules change approval process is gone through and something takes 6, 12, 18 months back and forth between the board and BHEC and the board and BHEC, public comments, the registry, and absolutely nothing of substance that matters is changed. That is where the disconnect comes from. Appreciate the time.
That looks like all the public comment that we have.
Thanks, everyone. Item 13, issues for future consideration. Anyone have anything to add?
When is our next meeting date and can we not move it? That would be most helpful.
Our next meeting date is April 28th. Can we not move it?
Yeah, moving this meeting is rather frustrating, but that's okay. All right, April what?
April 28th.
Okay.
And then, well, while we're at it, the meeting following that is now at August 4th. And I did want to verify, Dr. Bradley, August 4th works for you, correct?
My cursor was stuck. It wasn't in mute. I never know. When I came on the board, the meetings were in September, and August is the month for vacation. And I never know for sure about August. I suspect August 4th will work, but I can't say for sure.
I understand that, but you were able to check that it was not the day that you had graduation.
That's right. I checked that.
Okay, because I remember that was kind of a sticking point. I did want to verify that you were able to do August 4th. Board, we have kind of I guess BHEC has sort of grabbed the steering wheel and really turned this thing into a schedule to where each of our meetings falls before a BHEC meeting. And that's the reasoning behind why we are now at the beginning of August as opposed to September. Because really starting today, this was that course correction. Usually today's meeting is in early to mid-February, but we needed to get in front of the January 31st BHEC meeting. So that's why all these new proposed dates are a change from what we've had in the past, but that is the reasoning behind it. We need to be having our meetings a week, 10 days, 2 weeks prior to BHEC meetings. So that's why we're doing this. And just to make sure everybody's clear on this, we're not changing stuff willy-nilly. There was some reasoning behind it.
And Chair Hallbauer, the reason for that is to help the process of the rule review and getting these rules through the system a little bit faster where they're not hanging out so long.
Thank you.
And then before we sign off, Mr. Chair, I just a general comment for everybody that was concerned about the amount of rule changes that are occurring. I just want everyone to brace themselves because we have our mandatory, I believe, 4-year rules review after this session. So we are obligated to review every single rule, which we'll have a lot of fun doing in its entirety to ensure it is up to date to the highest standards of the state. So that'll be a very arduous and fun process. Very much looking forward to it. So that'll be exciting.
Dr. Taylor, that should begin or be done around December 2024.
Yeah.
All right, are there any future items? Okay, Christina, we go through the announcements and schedule items, item 14.
For 14, yes. So I will be attending the American Association of State Counseling Board Conference February 7th through 9th. Then we have the there's the Christian Counselors Conference that'll be February 16th through 18th. We have TASIS coming up, TASIS Conference March 12th through 3rd, which the board will be presenting at, I think it was on Thursday. And then we added that lunch and learn today for April 20th. Now, I wanted to go back and talk about the board calendar. So currently we have that August 4th date scheduled. But I do need to ask if the board would want to consider changing it to August 11th. The reason for that is there's a NBCC conference, which typically myself and at least one other board member is attending. And that falls on one of the days of the conference. So if not, that's okay. We'll, figure it out. But I wanted to bring it up to you all and see if you thought that would be okay to change it from the 4th to the 11th.
Christina, I'm okay with changing it, but we could also just, if I end up going with you, we can just zoom in, from where we are.
Yeah.
I'm also okay with the 11th. I'm checking my calendar now.
Yeah, I have no conflict on the 11th.
Dr. Bradley, would the 11th work for you? Was that a conflict date?
Well, again, that's the month that I'm free. The later in August that it can occur, the easier I can work around it.
Okay, all right, so that would be helpful. Vanessa, Pastor Roy, are you aware of anything that would be a problem with the 11th?
There are no conflicts on my end.
Not from my end.
Staff, you can verify that is prior to that BHEC meeting, correct?
The council meeting's on August 15th. At least that's what it is on the books right now.
Okay, so the 11th is really the last date we can do it. Right?
Yeah, I mean, it's pretty pushing it too.
Okay. All right, do we need to vote on this or can we just accept the 11th?
I believe we can just accept it.
Okay. All right, let's go ahead and move that to August 11th as opposed to the 4th, but we'll clear up Christina and Dr. Taylor's schedules. Anyone else going to NBCC?
We have not decided that yet.
I was going to say, where is it this year?
I think it's in Tennessee, but I'm not 100% sure. I don't remember. But typically they only allow for 2 spots. So otherwise it'll be just an extra fee for the agency, which I don't know how that would work. So, but we can, I'll send an email, see who's interested, and go from there.
Okay, then let's go ahead and make that change. It will be August 11th. Please
you.
see to it that the schedule's updated
Will do.
to reflect that. Any other announcements? Any other schedule items? No? All right, then. Great job, everybody. I will entertain a motion to adjourn.
So moved.
Thank you, Jane. Do I have a second?
Second.
Thank you, Dr. Bradley. Board, as always, thank you for your service to this great state. It's good to see everybody. Maybe someday we will be back in person. Happy New Year. Thank you for everything you do. Go Cowboys. All in favor, please raise your right hand. And we are adjourned. Take care.
Happy New Year, y'all.
Bye.
Hey, hour 47. Good job, guys. Good job.